Should a person who smokes marijuana on a regular basis have to forfeit their Second Amendment rights? I say no. But then again, it does not matter what I say or think. What matters is what the courts have to say about it. So if you're interested in finding out what a federal court of appeals recently had to say about marijuana users and firearms, be sure to stick around. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, and today we are going to discuss a ruling that came out of the United States Court of Appeals for the Fifth Circuit just last month. The case I'm discussing is United States versus Kennelly. The issue in that case was whether 18 U.S.C. 922G3, which prohibits unlawful users of or those who are addicted to any controlled substances, including marijuana, from possessing firearms or ammunition. Now, this isn't the first time the Fifth Circuit has addressed the constitutionality of 922G3. Back on August the 9th of 2023, a panel of judges from the Fifth Circuit found the prohibition to violate a habitual user of marijuana's Second Amendment rights in United States versus Daniels. However, the Daniels case was sent back to the Fifth Circuit by the United States Supreme Court after the Rahimi opinion was issued. Now, my guess is the Fifth will rule the same in the Daniels case as they did in Kennelly, considering the decision in Kennelly was issued after the U.S. Supreme Court's decision in Rahimi. So let's quickly go over the facts in the Kennelly case. El Paso police responded to Paola Kennelly's house in response to a shots fired call. Upon arrival at the house, police discovered Kennelly's husband, John, standing at their neighbor's door, letting off a couple of rounds from a shotgun. As you probably suspected, John was arrested. But after law enforcement spoke with Kennelly, who informed them that she at times smokes marijuana as a sleep aid for anxiety, they arrested her too. Kennelly was charged with violating 18 U.S.C. 922G3 by possessing firearms and ammunition as an unlawful user of controlled substance, and 18 U.S.C. 922D3 by providing firearms and ammunition to an unlawful user of a controlled substance, that person being her husband. Kennelly filed a motion to dismiss the charges, arguing that both charges were facially unconstitutional and that 922G3 was also unconstitutional as applied to her Second Amendment's right. The district court originally denied her motion to dismiss, but after the U.S. Supreme Court decided the Rahimi case, Kennelly filed a motion to reconsider her motion to dismiss. This time, the district court granted her motion for reconsideration and eventually granted her motion to dismiss as to the facial and as applied challenges. And of course, as you would expect, the government appealed. Before we go any further, I do want to take a minute to make sure we're all on the same page and know the difference between facial challenges and as applied challenges. A facial challenge is when you are contesting the constitutionality of a law itself. When a facial challenge is successful, then the law would be unconstitutional for everyone. Now, an applied challenge is when a person is contesting the constitutionality of a law as applied to that individual only. And if the challenge is successful, the ruling only applies to the person who brought the challenge. So an applied ruling will not affect other individuals who are not part of the court proceedings. As we all should know by now, when deciding whether a law violates the Second Amendment, a court first must determine if the individual's conduct falls under the plain text of the Second Amendment. In this case, we're talking about Kennelly's ability to possess a firearm as a habitual user of marijuana. Both the district court and the Fifth Circuit Court of Appeals found Kennelly belonged to the group of we the people, and that her conduct did fall under the plain text of the Second Amendment. Therefore, the Constitution presumptively protects her conduct of possessing a firearm and or ammunition. Now, in order for the restriction to be upheld, the government must show that the challenge regulation is consistent with the country's historical tradition of firearm regulation. In Rahimi, the Supreme Court reminded us that, like all other rights, the right secured by the Second Amendment is not unlimited. The government proposed three historical analogs to support the regulation: laws disarming the mentally ill, laws disarming dangerous individuals, and intoxication laws. As to the first analog proposed by the government, the court determined that the history and tradition surrounding laws disarming the mentally ill, did not address the problem comparable to 922G3. The court noted that the founders purportedly institutionalized lunatics and stripped them of firearms, yet allowed alcoholics to carry firearms while sober and possess them generally. And like historical intoxication laws, which applied restrictions only to presently intoxicated persons, our common law heritage has long recognized that mental illness is not a permanent condition. The court went on to write, since at least the time of Edward I, 1239 to 1307, the English legal tradition provided that those who had recovered their sanity should have their rights restored. Confinement of the mentally ill was limited to as long as such lunacy or disorder shall continue and no longer. This comports with the founding era conception of rights because that which a person recovered when he overcame a serious mental illness was his reason, the faculty necessary to exercise his rights. To sum up this historical text, the court basically determined that impairment from marijuana is more like a short-term mental impairment. And just like when the person recovers from that mental impairment, the person who is no longer impaired should be able to exercise his or her rights. Next, the government argued that people whom Congress deems dangerous can have their Second Amendment rights stripped, and that because Kennelly uses marijuana, she is now a dangerous person. This is where the Fifth Circuit Court of Appeals distinguished the Rahimi case from the facts in this case. The court wrote, but our history and tradition of disarming dangerous persons does not include nonviolent marijuana users like Paola. Indeed, not one piece of historical evidence suggests that at the time they ratified the Second Amendment, the founders authorized Congress to disarm anyone it deemed dangerous. Instead, the government presents a collection of different statutes disarming discrete groups of persons throughout history, which suggests an abstract belief that one's right to bear arms could be stripped if he or she were legitimately dangerous to the public. The analogs the government provided were laws that were passed during wartime or periods of unprecedented societal upheaval. The government identifies no class of persons at the founding who were dangerous for reasons comparable to marijuana users. Marijuana users are not a class of political traitors, as English loyalists were perceived to be, nor are they like Catholics and other religious dissenters who were seen as potential insurrectionists. And 922G3 is not limited to those judicially determined to have had a history of violent behavior or a propensity to engage in same, like those persons discussed in Rahimi 2024. Not all members of set drug users are violent. As applied, the government has not shown how Kennelly's marijuana use predisposes her to armed conflict or that she has a history of drug-related violence. Even as the founders disarmed Catholics and politically disaffected citizens, they left ordinary drunkards unregulated. The government provides no meaningful response to the fact that neither Congress nor the states disarmed alcoholics, the group most closely analogous to marijuana users in the 18th and 19th centuries. As with the analogy to mental illness, we must ask, which are marijuana users more like? British loyalists during the Revolution or repeat alcohol users? The answer is clearly the latter. So the government's attempt to analogize nonviolent marijuana users to dangerous persons fails to present a relevantly similar why. As to the government's last analog concerning intoxication laws, the court noted that the intoxication laws may address problems comparable to 922G3, but do not impose a comparable burden in doing so. The court determined that while some laws banned carrying weapons while under the influence, none barred gun possession by regular drinkers. When looking at the intoxication laws during the founding era, the court found that the intoxication laws primarily concerned military servicemen because, obviously, intoxicated servicemen cannot perform their duties while impaired. In closing, the court ultimately granted Kennelly's applied challenge as to her, but denied her facial challenges because 18 U.S.C. 922 G3 and D3 could operate constitutionally to ban presently intoxicated persons from carrying weapons and prohibit sales or transfers to such persons. Although this is not a direct victory for all marijuana users, it is a step in the right direction. Other federal circuits have found that the prohibition of firearm or ammunition possession by habitual users of marijuana to be constitutional. So for now, we're going to have to wait for the United States Supreme Court to resolve the conflict. I do believe that this prohibition will one day be found to be unconstitutional, especially considering all the states which have legalized marijuana use either recreationally or medically. Be sure to let us know what you think of the ruling down in the comments section below, where you can also leave any questions you may have about this video or any other Second Amendment or self-defense related question. Until next time, stay armed and educated.